Today is July 3rd, 2024. My name is Rob Carr of Kalamazoo Right to Life. This is Pro-Life Week. Well, I hope everyone is going to have a wonderful and patriotic 4th of July tomorrow as we celebrate our Independence Day. Okay. The last two programs, I spent it all exclusively on the pre-game show for the Biden-Trump debate. And then the post-game show was last time as we gave an analysis of how badly Joe Biden did. But we are going to turn a corner. I know there's been rumblings, the undercurrent across the country from Democrats and liberals and pundits saying that Joe Biden has to go and remove himself from the ticket. And I have my doubts that's going to happen. I mean, I really believe the families rallying around Joe Biden, especially First Lady Jill Biden. I mean, I think she really loves the trappings of power. I think she likes living in the White House. And I don't think she wants to give it up. So, the only way that Joe Biden is going to pull up and say, I'm out of here, is if she tells him that he's got to go. But I just don't see that happening. Okay, so let's move on from that debate. I talked about a week and a half ago about this judge. Her name is Seema Patel. She's a Court of Claims judge. She imposed a preliminary injunction on enforcement of Michigan's informed consent law, which has an attached 24-hour waiting period. And, she has done this in keeping with the guidelines established by Proposal 3, that has wreaked havoc on the Michigan Constitution in protecting our state laws that had been passed by pro-life majorities in the House and in the state Senate for the last 35, 40 years. It's all gone now because of Proposal 3. And what happened here, the backstory is last year the liberals in Lansing introduced the Reproductive Health Act. It was a package of 11 bills, and 9 of those bills passed because the Democrats control both State House and State Senate by very small, minute majorities. But one state rep from Detroit area, her name was Karen Whitsitt. She opposed 2 of those 11 bills, and one of them had to do with informed consent. And she said, basically, I'm going to paraphrase her, if you're going to terminate a pregnancy, it's not too much to ask that you be given 24 hours to think about that decision. If this is going to be a life-changing decision that you may regret the rest of your life, shouldn't you at least take 24 hours to think about that decision? Well, and then the other case that she voted no on was to remove our ban on state funding for abortions, taxpayer dollars being used for abortions. It's been state law since 1988 that Michigan taxpayers do not have to fund abortions for poor women. We don't have to do that. Kind of in keeping with the federal Hyde Amendment. And what happened now is that, I'm going to read to you a little quote from an article from the Detroit News dealing with this issue. Quote, this is spoken by a person, I think, I'm not even sure who this person is. The last name was Katiba? I'm not sure. Quote, the legislature had an opportunity to repeal this harmful and outdated law, and they did not get the job done. So now it's up to the courts to make sure that this law is struck down because it is clearly in conflict with the right to reproductive freedom now enshrined in the Michigan Constitution. Okay, so clearly, if it didn't pass legislatively, the backup plan was to go the backdoor approach through the courts. And they found a judge was appointed by Governor Whitmer, and this judge is now striking informed consent down. And I'm going to read just a portion from a Supreme Court decision called Thornburg versus American College of Obstetricians and Gynecologists. It was decided June 11th, 1986, and the case dealt with Thornburg was a governor of Pennsylvania, I believe, and the state had enacted a series of laws, and one of them had to do with informed consent. And the Supreme Court struck that down. And Chief Justice Warren Burger, who back during Roe v. Wade had actually voted with the 7-2 majority in favor of Roe. Well, now in 1986, he has this epiphany and realizes the court has gone way, way too far, and he dissents with the minority in this case. So I'm going to read just briefly what he has to say about informed consent that just Judge Patel now thinks is so evil. Okay, this is from Chief Justice Burger. Today, the court astonishingly goes so far as to say that the state may not even require that a woman contemplating an abortion be provided with accurate medical information concerning the risks inherent in the medical procedure which she is about to undergo and the availability of state-funded alternatives if she elects not to run those risks. Can anyone doubt that the state could impose a similar requirement with respect to other medical procedures? Can anyone doubt that doctors routinely give similar information concerning risks in countless procedures having far less impact on life and health, both physical and emotional, than an abortion, and risk a malpractice lawsuit if they fail to do so? Yet the court concludes that the state cannot impose this simple information dispensing requirement in the abortion context where the decision is fraught with serious physical, psychological, and moral concerns of the highest order. Can it possibly be that the court is saying that the Constitution forbids the communication of such critical information to a woman? Okay, Warren Burger, 1986, the Thornburg decision. At that time, the court said, no, you cannot force or impose a law forcing informed consent. And Warren Burger says, what other procedures can that be applied to? And I've mentioned several times now that even though the pro-abortion people say that abortion is healthcare, it's the new mantra. They seem to classify abortion as a political operation. It's a medical procedure. It's a medical operation. But for Democrats, it is a politically motivated medical procedure. And it doesn't have to abide by the regular common sense regulations that other procedures do. I mean, Proposal 3 removed clinic licensing. You know, what kind of a clinic or a hospital doesn't have to have safety inspections? Abortion clinics don't anymore. You know, they don't have to report on how many procedures they do. They don't have to report on how many cases where there were complications, where a woman maybe had to go to a hospital to be fixed, to have some repair from a hemorrhage. There are no reporting, there are no guidelines, there are no safety standards, there are no inspections. Abortion has become a political operation, but it's still healthcare. But it is all by itself in its own protected class, which is horrendous. How is that safe for Michigan's women? How is that safe? It is not safe for them to be denied informed consent. Okay. Moving on. I also found this out just recently, this past few days, that the ACLU, the Michigan branch of the ACLU, and the YWCA of Kalamazoo, my hometown, has filed a lawsuit challenging our ban on state funding for abortions. And so this is just the beginning. But here again, it didn't pass in the Reproductive Health Act last year. It didn't pass. And now they're going the back door through the courts to have a judge rule. Oh, yeah. Taxpayers must start paying for abortions for poor women. You cannot deny, if a woman can have the right to an abortion and she can't pay for it, the taxpayers are obligated to pay for that woman's abortion. And our law said no, but don't be surprised if a judge rules that our 1988 law is against the state constitution based on Proposal 3. Proposal 3 has done more damage because of the ambiguities in the wording of that proposal. And, going back to informed consent, I got to get a quote here from Governor Whitmer. She's talking about the whole issue of reproductive health, and she says here, by removing these barriers to reproductive health care, we will ensure that Michigan is a state where you can make the medical decisions that are best for you and your family in consultation with your doctor. Well, that's not the case anymore, because included in Judge Patel's requirement about striking down informed consent is also another category of Proposal 3 that says that non-physicians can now perform abortions. I talked about 2 weeks ago about in the past that the whole, one of the great motivators for the pro-choice movement was to protect women by making sure that non-physicians be able to perform abortions. These quack doctors who were not licensed physicians, they wanted to make sure that a licensed doctor could do an abortion in a safe clinical setting to safeguard a woman's health. Well, now, according to Proposal 3, all you had to be is a licensed health professional. So a midwife, a PA, a physical therapist, a veterinarian. I mean, it is so ambiguous. Where do you draw the line on who can perform abortions? Well, it's no longer just your doctor. It's now a licensed health professional. So I know these are distressing developments here in Michigan, and some of these things are almost out of our control because I don't think we have ability to make a lot of legal challenges. But there is an election coming up, and if the voters in Michigan can deliver a pro-life majority in the state house, we can at least put a stop to further damage from what our governor is and her pen is trying to do. Because to get a bill passed, as we all know, you have to have a majority approval from the state house and the state senate. And if we can get the state house back, we can block Governor Whitmer's abortion rights agenda. We can do it. And with that thought, I'll let you go, and I'll see you next time.